Norway. Around 930 AD, a woman is standing at a bedroom door. She has witnesses. She has already said the words once, at the main door of the house in front of the household. Now she says them again here at the bedroom threshold. She will say them one more time at the main gate before the sun sets. 3 declarations, 3 locations. Marriage dissolved. No priest, no court, no male guardian signing anything on her behalf. The law required her voice, her presence, and her witnesses. That was all. This happened in a society that existed before the first cathedral was built in Scandinavia, before canon law reached the fjords, before the church declared marriage a sacrament and handed enforcement of that sacrament to an institution that would spend the next 1,000 years deciding what women's bodies were for. The question isn't whether Norse society was egalitarian. It wasn't. The question is something harder and more specific. In the complete absence of a church and a centralized state, who actually held legal authority over sex, marriage, and children? And how was that authority enforced? And the last layer, it has nothing to do with sexual freedom. Medieval Christendom had the most comprehensive marriage control apparatus in human history. Canon law, confession, excommunication, annulment proceedings that could run for decades. The church had jurisdiction over every aspect of conjugal life and the bureaucratic machinery to enforce it. By the 11th century, a peasant woman in France or England could not dissolve her marriage under any ordinary circumstance. Her husband could beat her within limits the church itself defined. Remarriage after a living spouse required a papal process most people could not access and almost none could afford. The church also had something else. It had a theological framework that classified female sexuality as inherently dangerous, inherently subordinate, and inherently subject to male and institutional control. Augustine Jerome, the long tradition of patristic writing that ran from the early church fathers straight through to Gratian's Decretum in the 12th century. One unbroken line of institutional logic. Women's bodies were a problem to be managed. The Norse had none of that infrastructure. No pope, no canon law, no confession, no sacramental theory of marriage that made dissolution a theological impossibility. What they had instead was the Grágás, the Grey Goose Laws of Iceland, a legal code containing more than 40 distinct provisions governing marriage, concubinage, divorce, sexual conduct, and the legal status of children born outside formal marriage. Dense, precise, procedural, not a romantic document, a legal operating system. Both systems were calculating. The church wanted absolute control over human reproduction to secure the political and financial hierarchy of the state. What did the Norse want? They wanted a functioning unit. In an environment that routinely kills the careless, a bad marriage is not merely a theological problem. It is a practical and immediately fatal liability. A weak partner gets you killed. There's an image most people carry when they think about Norse marriage. Feasting halls, bride prices, a transaction between 2 male households with a woman moved from one to the other like livestock. The archaeological record and the legal record tell a different story. Ibn Fadlan, writing around 921 AD after direct observation of Norse traders on the Volga, documented something that confused him deeply. The women he observed had genuine transactional authority. They wore key rings, not as symbols but as actual instruments of household control. The keys opened real locks on real storage. He noted this as a distinguishing feature, a thing worth recording because it was not what he expected. The Landnama book, the Icelandic book of settlements, records women as independent landowners, farm founders, and legal agents in their own right. Not as exceptions, as a pattern. The Oseberg ship burial, dated to 834 AD, contains 2 women interred with the material wealth and ceremonial treatment of individuals who held real institutional power, not symbolic power. Their own. The Hollywood version puts a male hand on every document. The sources don't. The answer isn't one solution. It's a system, and each layer is more deliberate than the last. A man drags a heavy iron-bound chest across a rough timber floor, pushing it toward a woman. He releases the iron handle. He steps back. The silver inside isn't his anymore. This is the heimanfylgja, the bride's portion. The rough translation doesn't capture what it actually was. Here's the detail that changes everything. The heimanfylgja was not a gift given to the husband. It was property transferred to the wife, property she retained legal control over for the duration of the marriage and reclaimed in full upon dissolution. Her name on it, her authority over it, not held in trust by a male guardian, not absorbed into the husband's estate at the moment of marriage. She received it. She managed it. She took it back. The mechanism worked like this. Before the wedding, the bride's family assembled the heimanfylgja: land, livestock, movable goods, sometimes silver. The groom's family assembled the munder, the bride price, paid to the bride herself under Icelandic law, not to her father. At the wedding, both were formally declared in front of witnesses. The amounts were recorded. Then the marriage began, and both parties entered it with legally distinct property portfolios. She counted the hacked silver. She wrapped the dyed textiles in oiled leather. She locked the chest and kept the iron key hanging from her own belt. It was a constant physical reminder of what was hers. A woman in 11th century France owned nothing the moment she married. Her property, her person, and her labor became her husband's by law and by theological principle. A woman operating under Grágás walked into marriage holding assets that remained legally hers throughout. Textile archaeologist Michelle Smith, working across Norse Greenland and Iceland sites, has documented the material evidence of female economic authority. Looms, weighted spindles, finished cloth inventories that corroborate the legal picture the Grágás describes. Women controlling production. Women controlling the surplus. Women with something real to take back when they walk to the door. Modern community property law, the principle that spouses hold distinct and traceable property interests that survive marriage dissolution, didn't reach most of continental Europe until the 19th century. In some jurisdictions, the 20th. Norse customary law was operating on functionally identical principles roughly 800 years earlier, enforced not by a state bureaucracy but by the social mechanism of witness declaration and the family networks that backed it. That gets you to property. It doesn't get you to the second track, the legally recognized institution running parallel to formal marriage that most accounts of this period either ignore entirely or misrepresent completely. A woman stands by a hearth fire pouring ale for a visiting chieftain. She wears keys of authority on her belt but no bridal linen on her head. She is a frilla. The word gets translated as concubine, and in doing so, almost everything important about it gets lost. A frilla was not a mistress in the modern sense. The word carries the wrong connotations. Secrecy, shame, social penalty. None of those applied. A frilla was a legally recognized secondary partner. The relationship was acknowledged. The children born from it had legal standing. Under certain conditions, those children could inherit. The Grágás and related Norwegian law codes specify the inheritance rights of frilla-born children with the same procedural precision applied to everything else, not equal to legitimate children in all circumstances, but not nothing. Not erased. The mechanism. Her father negotiated the contract. The chieftain agreed to the terms. Witnesses were present. They acknowledged the relationship publicly or not at all, because an unacknowledged frilla had no legal claim, which meant he had no legal protection either. Both parties had something to lose. Both parties had something to gain. Pull a frilla-born son out of the Icelandic sagas and you pull out half the significant characters in them. Magnus Barelegs. Several of the early Icelandic chieftains recorded in the Landnama book. The institution wasn't peripheral, it was load-bearing. Here is what that actually meant for the formal wife. She had legal tools. She could, under specific conditions established in Norse law, dissolve the marriage if the frilla relationship crossed thresholds the law defined, if resources were diverted in ways that violated the marital property arrangement, if the secondary relationship produced obligations that damaged her household standing. The frilla institution had edges. The formal wife's legal position defined where those edges were. If you've ever had to make something work with whatever was actually in front of you, not the ideal structure, not the clean arrangement, but the actual competing claims of actual people operating in close quarters. You recognize this kind of thinking. The Norse didn't legislate desire out of existence. They built a legal architecture around it. Some scholars argue the frilla institution was simply practical necessity. A society with high male mortality, long voyages, and irregular household formation couldn't enforce strict monogamy and didn't try. Others point to the Grágás inheritance provisions and the formal recognition structures and call it deliberate social engineering, a calculated way of absorbing illegitimacy into the legal order rather than letting it destabilize property transmission across generations. Pragmatic adaptation or design system. The comments are open. If this is the kind of detail you come here for, a like takes a second and genuinely helps. The property layer changed the material conditions of marriage. The frilla institution absorbed the reality of competing relationships into a legal order. Neither of those touched the most volatile question. What happened when the marriage itself failed? And who had the right to end it? A Norse marriage could be dissolved by either party for reasons the law specified in writing. Grounds included failure to provide economically persistent absence without consent, physical abuse beyond customary limits, and this is the entry that requires a second reading. Sexual incompetence, defined in the Grágás for both the husband and the wife. A man who could not perform his conjugal obligations could be divorced for it. A woman who could not or would not was subject to the same grounds. The law was not symmetrical in all respects, but it was symmetrical here, and the symmetry was not accidental. The dissolution procedure itself had a physical architecture. The woman, or the man, appeared at 3 locations within the household. Main door, bedroom threshold, outer gate. At each location, the declaration was made aloud in front of witnesses. The witnesses were required. The words were required. The sequence was required. Miss any element and the dissolution was invalid. This was not informality, this was precision. A legally binding act performed through a prescribed ritual sequence with named witnesses whose testimony could be called in later dispute. A clerk pressing a seal into hot wax in a Frankish chancellery was doing the same thing, converting a spoken act into a legally durable fact through a witnessed procedure. The Norse version used no wax and no clerk. It used the household threshold and the human voice. Anyone who has ever had to negotiate from a position where the law was actually on their side, where the written rule existed and could be enforced, understands what that changes about the conversation. It changes everything about the conversation. In Catholic doctrine, a valid consummated marriage could not be dissolved. Full stop. The Church might grant an annulment, a declaration that the marriage had never been valid. But the grounds were narrow, the process was expensive, the outcome was uncertain, and the institutional bias ran heavily against the petitioning party, especially if that party was a woman. Divorce, as a legal concept granting both parties the right to remarry, did not exist in Catholic Europe. The Norse dissolution procedure was not romantic. But it was over when she said it was over, not when a court decided, not when a church permitted. One problem closed, a harder one remained. Divorce rights and property control described the formal structure of marriage. But Norse society also had to manage something no legal code can fully contain: the connection between a man's sexual conduct and his standing as a legal agent. That connection had its own category, and it is the most architecturally strange thing in the entire system: a sound. The heavy thud of an iron-bound wooden maul striking a birch pole. A man is driving that pole deep into the frozen earth. He mounts a severed horse's head on the top. He props its wet jaws open with a stick. He points the dead eyes toward a neighbor's farmstead, carving specific damning runes into the wood. He is not casting a magic spell. He is executing a legal strike. This is nith, a formal public accusation of sexual passivity, specifically the accusation that a man had taken the receptive role in a sexual act. The accusation did not have to be true. It had to be made publicly with witnesses, and if it was not immediately and forcefully rebutted, it stuck. And if it stuck, the legal consequences were real. A man formally accused of nith and unable to rebut it could lose specific legal rights. His testimony carried less weight. His capacity to function as a full legal agent degraded. The Grágás treats nith as a crime so inherently destabilizing that, simply speaking, the accusation gave the target the legal right to kill the speaker on the spot. No trial required. Historian Preben Moilengracht Sørensen documented the nith system in detail in his work on Old Norse concepts of honor. What he found was not a simple homophobia. The Norse sources don't condemn the active partner in a same-sex act. The condemnation was specifically positional. Passive was the problem, because passive, in Norse legal logic, mapped onto a social role incompatible with full legal agency. A modern military parallel exists, and anyone who has served will recognize the structure immediately. The rules aren't about what you do in private. They're about whether the group can rely on you to hold a position. Whether you will stand when standing is required. The Norse legal system mapped that question onto the body and encoded it in law. If you've served in a unit where your standing with the men around you depended entirely on whether you held your position when it mattered, not on what regulations said, but on what the people next to you saw, you understand exactly how this enforcement mechanism worked. No court required. The accusation itself was the pressure. Answering it was mandatory. Here's something that almost never appears in the popular version of this story, and it may be the most counterintuitive layer of all. The Grágás law code contains consent provisions for sexual acts that are more precisely defined than the laws governing the same acts in most European jurisdictions, until well into the 20th century. Here's the detail that changes everything. The Grágás doesn't treat consent as the absence of no. It treats consent as the presence of yes, a positive, witnessed, socially legible act. And its absence triggers legal consequences with the same procedural weight as property violations. The law distinguishes between categories of sexual act by the presence or absence of consent with a specificity that reads, to a modern legal eye, as surprisingly technical. Forced acts against a woman carried specific penalties. Those penalties were not framed as offenses against her male guardian. The framing most European legal systems used, treating violation as a property crime against the father or husband. They were framed as offenses against her, Her body, her standing, her claim. The enforcement mechanism was imperfect. The social pressure on women not to bring claims was real. The Grágás was not a feminist document. It was a legal code produced by and for a stratified society with significant male power concentration at its upper levels. But the legal language was there, written down, specific, referring to her as the injured party. Most of English common law didn't reach that framing until the 19th century. Several jurisdictions didn't reach it until the 20th. That doctrine survived in English law in various forms until 1991. Not a medieval artifact, 1991. The Grágás was finalized in its earliest manuscript form around 1117 AD. That is not primitive law. That is elegant engineering. Step back from the details for a moment. What holds this system together is not any single provision, it's the underlying logic. Authority over sex, marriage, and reproduction was distributed across the woman, the husband, the household, the witnesses, the community assembly. No single institution owned it. The heimanfylgja kept property in her hands before the marriage began. The divorce procedure gave her the mechanism to exit when it failed. The frilla institution absorbed the reality of competing relationships into a legal order rather than pretending they didn't exist. The Nith system encoded the connection between the body and legal personhood into carved wood and public challenge. The consent provisions named her as the injured party and wrote it down. None of it was accidental. Every layer was the product of generations of knowledge tested, refined, and paid for in lives. In bad marriages that destroyed households, in property disputes that split communities, in the slow accumulation of hard cases that forced a society without courts or clergy to build precision into its spoken law instead. A modern state marriage apparatus requires a license, an officiant, a registration, a dissolution proceeding. Remove any one layer, and the system fails. The Norse system had no single point of failure. It ran on witness declaration, social enforcement, and the memory of the people who were present. The Church spent 1,000 years building an alternative system. One institution, total jurisdiction, theological enforcement. It was more legible. It was more durable across large territories. It also required women to disappear as legal agents entirely. The Norse system required witnesses instead. If the question of how a society without priests or parliaments wrote consent into law, distributed authority over the body across a community rather than concentrating it in an institution, and built a marriage system that a woman could exit by walking to 3 doors. If that question is what brings you here, subscribing means you'll be here when the next piece arrives. There is more underneath. There always is. Norway, around 930 AD. She is standing at the bedroom threshold again. You know what she's holding now. Not just her nerve, not just her anger or her grief or whatever specific failure brought her to this doorway on this particular morning. She is holding a legal procedure, a written right, a set of words that the law had already recognized before she spoke them, that the witnesses behind her were already prepared to remember, that the assembly would already know how to process when the dispute arrived there. She felt the wood of the doorframe under her hand, rough cut, resin dark, cold from the draft coming off the water. The witnesses were quiet. This is not the moment for commentary. She turned and walked to the front door, said them again, walked to the gate, said them a 3rd time. The iron key hung heavy against her hip. Everything it opened was still hers. No institution had given her that right. No institution could take it away. The law was the words, and the words were hers. One built cages. The other forged keys.